Well, first I want to just thank everybody for putting this together and for having this. Thank you to the Duke people. Thank you for Notre Dame Law Review. And then also thank you for all the people that have presented here today and submitted the papers ahead of time. I read all of the papers and I really learned a lot from every single one of them. So I've complimented some of you personally on kind of how it's helped me, and I wanted to just do that publicly to everybody. One of the sayings I believe in is that if you're the smartest person in the room, you're in the wrong room. So I think that perhaps I'm definitely in the right room today, and happy to be here with you. I want to talk a little bit about my experience, how I got involved in some of these cases, and then touch very briefly on my perspective looking at it, which perhaps is different than some of the other perspectives in this room. I've only been teaching full-time for a very short period. Before that, I was an appellate attorney with the Federal Public Defender's Office for about 8 years. I was in the Northern District of Texas, which includes Dallas, Fort Worth, Amarillo, Lubbock, Texas, and then a few other smaller towns. And the Northern District of Texas is quite unique in two ways. First, it's one of the highest volume districts for federal prosecutions of all crimes. And second, at least in fiscal year 2021, it was tied for the most number of federal firearms prosecutions. So just coming through our office were so many gun prosecutions. And that's kind of how I started to get involved in all of these cases. In 2019, I argued and won United States versus Davis at the Supreme Court. Striking down part of the definition of crime of violence from a very common federal firearms statute called 924C. Then, a couple of years later, or even less than that, I was appointed in a case called United States versus McGinnis. And that was kind of Rahimi before Rahimi. It was a 922G8 prosecution. And that's when I started to get kind of really deep away from some of the vagueness and then away from some of the categorical approach stuff I was doing prior to that, and really start to focus in on this kind of post-Heller Second Amendment interpretation. And in working on that case and looking at some of the dissents and concurrences among the circuit courts, kind of starting with then Judge Kavanaugh's dissent in what's called Heller 2 that was mentioned earlier, you start to see kind of this groundswell of mostly kind of conservative judges and justices that are starting to look at whether the circuits kind of got it right when they were interpreting Heller and how we go about evaluating constitutional challenges to some of these gun crimes. You saw a growing support for this text history tradition approach away from means-in scrutiny. And so I really started to develop that working in McGinnis. I know a lot of people made the observation earlier. I really wasn't that aware of it at the time, and but probably got a lot out of reading some of the articles that some of you had written before I even knew who some of you are. So I've been learning about it for some time, grateful to be meeting you. But that's when I worked on McGinnis. I argued McGinnis at the Fifth Circuit, and it was the first kind of case where the Fifth Circuit considered it. Ultimately, the Fifth Circuit decided that they were perhaps bound by a prior holding applying means-in scrutiny. Yet, before the panel, 2 of the 3 judges wrote a concurrence saying, we think we need to revisit our methodology, revisit our approach to evaluating these sorts of things. I moved for rehearing en banc in McGinnis, and the court was equally divided, so rehearing wasn't granted. Then the Supreme Court denied cert. That was a time when Justice Ginsburg was still in the court. It seemed clear that Justice Roberts wasn't on board with changing anything. And so there wouldn't have been enough support at that time at the Supreme Court to change the methodology. I spent the next year or year and a half trying to find kind of a similarly situated defendant to re-raise some of these same arguments. Ultimately, I came across Mr. Rahimi, who was prosecuted in Fort Worth, Texas, in the Northern District of Texas, assisted with the trial attorney to preserve these arguments at the trial level. Preservation, as we just heard, is a big part of what we do, often in the form of a motion to dismiss the indictment early on. And then was appointed on the appeal at the Fifth Circuit. I filed the appellate brief, but conceded that we have to lose under McGinnis. The only way the Fifth Circuit can change its own law is through sitting en banc. They adhere to something called a rule of orderliness that I think probably all circuits adhere to. So then I moved for rehearing en banc. While the case was pending, while that motion was pending, the U.S. Supreme Court issued its opinion in Bruen. The Fifth Circuit then automatically sua sponte vacated the panel opinion and set it for oral argument and requested supplemental briefing. I did the supplemental briefing before the Fifth Circuit, and it was right at that time I made the wonderful decision to leave the office and give the case to someone else. So I went to teach full-time, and one of my colleagues, Matthew Wright, who's going to be arguing on Tuesday, he got involved in the case, and his first involvement was presenting the oral argument in Rahimi. From there, we felt pretty sure that the government was going to move for rehearing en banc at the Fifth Circuit. And then we realized when that deadline passed that it was going to go in a different direction. The government sought cert straight away. They had actually done the same thing in Davis in 2019, so we had seen that before. And unlike when we seek cert, where we've got far less than a 1% grant rate, the government has about a 70% grant rate seeking cert last I saw. So last summer, the Supreme Court granted cert in Rahimi, and we've spent kind of ever since then starting to think about the brief writing process. Of course, we're respondent, so it's hard to kind of write the brief straight away. But we did a lot of the research as much as we could beforehand, and of course, we knew some of the arguments the government would certainly need to make in the case. Once the government filed their merits brief, and I'm skipping over the whole brief and opposition stage, there's a whole middle stage to all of this. We spent the last several months writing the respondent's brief, and so we turned that in a while back. The government just filed their reply recently. And my friend Matthew is arguing it on Tuesday, so I'm going to go up there and support him. And I know that makes me, to a certain extent, kind of the bad guy in the room, and I'll acknowledge that, and also say that I'm not here to persuade anybody of my position. I do want to talk, just touch very briefly on kind of where I'm coming from. You know, coming from this high-volume federal firearms prosecution district, you know, what we see, if you were to look up on Westlaw, and I don't know if it's true or not, but according to Westlaw, I filed 410 appellate briefs with my name on it, mostly at the Fifth Circuit. A very significant percentage of those are federal firearms prosecutions. So of those 410, probably 300 of those people are still in federal prison, many for the mere possession of a firearm. And that's an important distinction that I think some of the headlines often miss, is that particularly the 922G offenses are almost universally felon in possession and almost universally for the mere possession of a firearm. Anytime you see the misuse of a firearm, as you also see, at least in the form of allegations against Zaki Rahimi, the Supreme Court case will not affect any of those charges. So he's facing significant charges in state court for every single time he ever pulled the trigger, every single time he ever laid a finger on anyone. The federal case is on his possession of a firearm. So my perspective on this case is not one as a gun libertarian. In fact, I don't own a firearm. I don't like being around firearms. I'm one of the people that walks out of the restaurant when someone walks into the restaurant with a firearm. But what I think about a lot is mass incarceration and the number of federal firearms prosecutions and how that number has increased significantly in the last 30 or 35 years. So I wrote an article about this called The Federal War on Guns, not from some sort of NRA perspective, although I know the title is kind of provocative, but really looking at the history of executive branch enforcement of federal firearms statutes, how that's changed, and then starting to talk about perhaps why it's changed. So when I think about these cases, I think about all of my clients who are in prison for possessing a firearm, many of whom have never laid a finger on anyone. yet they're now punishable by up to 15 years in prison, thanks to an amendment to the statute signed by President Biden. And at least last I checked in fiscal year 2021, we're prosecuting at a higher rate than we ever have in our nation's history. And so I wanted to just kind of share my point of view on these types of things, not to persuade anyone. I know that this is a very difficult topic and it's personal, and I'm sure that we're going to hear more about that, and I share those concerns. I have 3 small children. But there's a competing interest that maybe isn't talked about as much in the literature, and that's how it affects defendants who have admittedly committed a crime. But when we see a tool that we can use to push back on what I see as too much federal involvement in criminal law, I see that as a good thing. I say that with all the qualifications for all the reasons you've heard here today, but I did want to kind of share the defense perspective on that point. So thank you very much.